Australia's constitutional inheritance. Lecture 3. The Inherited Protections. Common law structure and the assault from within. Australians often talk as if the Constitution is a complete code, as if everything we need to know about constitutional government can be found within its four corners. It is not. It is a framework document that presupposes an entire civilization. The Constitution was never meant to stand alone. It was meant to operate within a framework of common law, assumptions, inherited principles, and institutional arrangements that stretched back centuries. The document made sense only against that background. Consider what the Constitution does not say. It does not define what a court is, though it vests judicial power in courts. It does not explain what responsible government means, though it assumes responsible government throughout. It does not catalogue the rights of subjects, though it assumes those rights exist. It does not set out the rules of statutory interpretation, though it expects statutes to be interpreted. By all of this was inherited. The founders did not need to spell it out because everyone in 1901 knew what they were talking about. The common law, the Westminster Conventions, the habits of parliamentary government, these were the background against which the Constitution was written and against which it was meant to be read. This is the great unwritten truth of Australian constitutional law. The Constitution is not a comprehensive code. It is a framework document that presupposes an entire civilization. The common law inheritance. What did Australians inherit when they inherited the common law? Start with a story. In 1765, the King's messengers broke into the house of John Entick, a writer who had published pamphlets critical of the government. They spent 4 hours ransacking his belongings, carrying away his papers and books. Entick sued for trespass. The government argued that a warrant from the Secretary of State authorized the search. Lord Camden, Chief Justice of the Common Pleas, was unimpressed. The power claimed by the government, he said, had no foundation in law. Such a power existed. It would have to be found in statute or in precedent. There was no statute. There were no precedents, only the government's repeated assertions of authority. If it is law, Camden declared, it will be found in our book. If it is not to be found there, it is not law. Government lost. Entick received damages, and a principle was established that would echo through the centuries. And the executive cannot simply assert powers it finds convenient. Its authority must be grounded in law, real law, found in statutes or in the accumulated decisions of the courts. The mere claim of necessity is not enough. This is what the common law does. It protects liberty, not through grand declarations, but through the ordinary operation of the courts. When the government oversteps, when officials exceed their authority, when the powerful trample the weak, there is a remedy. You can sue. You can go to court. You can hold the wrongdoer accountable. The common law developed over centuries in England, case by case, judge by judge. It was not designed by anyone. It evolved, tested by experience, refined through argument, adapted to changing circumstances. It embodied, as Burke would have recognized, the accumulated wisdom of generations. And when the first British settlers arrived in Australia, they brought it with them. This was not automatic. There was debate about whether English law applied to a settled colony, and if so, which parts. General principle was that settlers carried with them so much of the law of England as was applicable to their new situation. The common law applied. Statutes might or might not, depending on their nature and relevance. By the time of Federation, the Australian colonies had been applying the common law for over a century. Their courts had built up their own body of precedent, adapting English principles to Australian conditions. The new Commonwealth inherited all of this, not by explicit provision of the Constitution, but by the simple fact of continuity. The courts continued, the law continued, the protections continued. What protections? Consider just a few. The presumption of innocence. A person accused of a crime is presumed innocent until proven guilty. The burden is on the prosecution. If there is reasonable doubt, the accused goes free. This is not in the Constitution. It is common law older than any Australian document. Right to silence. You cannot be compelled to incriminate yourself. The prosecution cannot comment adversely on your failure to testify. This, too, is common law, the rule against double jeopardy. Once acquitted, you cannot be tried again for the same offense. The state gets one chance. If it fails to prove its case, you walk free. The system prefers that the guilty escape than that the innocent be persecuted. The requirement of mens rea for most serious crimes, the prosecution must prove not just that you did the act, but that you had a guilty mind, intention, recklessness, or at minimum negligence. Accidents are not crimes. Right to a fair hearing before the state can take action against you. You are entitled to know the case against you and to answer it. You must have a genuine opportunity to be heard. The decision-maker must be unbiased. The principle of legality. Statutes are interpreted on the assumption that Parliament does not intend to interfere with fundamental rights unless it says so clearly. Ambiguous provisions are read in favor of liberty. Beware the modern language of exemptions and carve-outs. Under the common law, liberty needs no exemption. It is the starting point. The burden is on those who would restrict it to justify the restriction, not on free people to justify their freedom. When legislators speak of carving out protection for free speech or fair comment, they have already inverted the common law presumption. They are treating regulation as the baseline and freedom as a special dispensation, a gift from the benevolent state. This is not the common law inheritance. It is its negation. To be clear, I am not denying the statutory status of Australian citizenship. I am making a narrower constitutional claim. Citizenship is not entrenched in the Constitution itself, and therefore does not perform the same restraining function as inherited subjecthood. Beware, too, the language of exclusion. To say a group was excluded from Commonwealth power presupposes that such power was an entitlement, that being legislated about is the natural condition, and its absence a wrong. Under common law reasoning, the reverse is true. The absence of legislation is not exclusion. It is the ordinary condition of free subjects. When we are told that Aboriginal people were excluded from the Constitution, we should ask, excluded from what exactly? From having the Commonwealth make laws about them? That is not exclusion. That is being left alone. Habeas corpus. If you are detained, you can demand that your jailer bring you before a court and justify the detention. Unlawful imprisonment has a remedy: immediate release. None of these are in the Constitution. All of them were part of what Australians inherited, and all of them are older than Australia itself, some by centuries. This is why the founders did not include a Bill of Rights. They did not think they needed one. The rights were already there, embedded in the common law, protected by the courts, part of the legal inheritance every Australian possessed. A Bill of Rights would have been redundant at best, dangerous at worst. Redundant because the rights already existed, dangerous because listing some might imply that others did not exist. Americans had made a different choice in different circumstances. They had fought a revolution against the Crown. They distrusted government profoundly. They wanted explicit limits, written down beyond the reach of ordinary legislation. A Bill of Rights reflected their history. The Australians had not fought a revolution. They received self-government as a gift, not a conquest. They trusted their institutions, the courts, the parliament, responsible government. They saw no need to chain future generations to a list of rights drafted in 1901. The common law was flexible, it could adapt, and the structure they had built, federalism, responsible government, an independent judiciary, would provide checks enough. Whether they were right is a question we shall consider. But first we must understand what that structure was, and how it was supposed to work. Federalism, the vertical division. The Australian Constitution created a federal system. This is its most distinctive feature. What makes it different from the British Constitution, from which so much else was drawn? Federalism means divided sovereignty. The Commonwealth has certain powers. The states have others. Neither is supreme over the other in all matters. Each is supreme in its own sphere. Why did the founders choose federalism? Not from abstract theory, but from practical necessity. The 6 colonies were separate, self-governing entities. Each had its own parliament, its own laws, its own tariffs, its own public service. They were not going to abolish themselves. Any union had to preserve their existence and their powers. The result was a constitution that gave the Commonwealth only those powers the colonies were willing to surrender. These were listed enumerated in Section 51, Defence, Customs, Immigration, Posts and Telegraphs, Marriage and Divorce, Banking, Insurance, and others. The list is long, but it is a list. What is not on it remains with the states. This was not centralization. It was the opposite. The founders assumed that most government activity would remain with the states. Education, health, police, land management, most economic regulation, these were state matters. The Commonwealth would handle national concerns. Defence, external affairs, trade across borders. Domestic government would stay close to the people, administered by states that understood local conditions. The Senate was designed to protect this arrangement. Equal representation for each state, regardless of population. 6 senators from New South Wales, 6 from Tasmania. Though New South Wales had 20 times the people, the Senate could block legislation that threatened state interests. It was the states' house, their voice in the federal parliament. And Section 51 itself was a protection. The Commonwealth could legislate only on the enumerated matters. If it tried to legislate on something not in Section 51, the law was invalid ultra vires, beyond power. The High Court could strike it down. This is vertical separation of powers. The American system has horizontal separation. Executive, legislative, judicial, each checking the others. Australia has that too, in its own way. But federalism adds another dimension. Power is divided not just among branches, but among levels. The Commonwealth cannot absorb the states. The states cannot ignore the Commonwealth. Each operates within its constitutional limits, or so the founders intended. The expansion of Commonwealth power. What actually happened was different. From the beginning, the High Court was called upon to interpret the Constitution, to decide where the boundaries lay between Commonwealth and state power. The early High Court, under Chief Justices Griffith and later Knox, took a restrictive view of Commonwealth power. They interpreted Section 51 narrowly. They protected what they called the reserved powers of the states, the idea that certain matters were inherently state matters beyond Commonwealth reach, regardless of how Section 51 was worded. But the court changed. Engineers' Case 1920 was the turning point. The High Court, now led by different judges with different views, abandoned the reserved powers doctrine. Henceforth, Commonwealth powers would be interpreted according to their natural meaning, without any implicit limitation derived from state sovereignty. If the words of Section 51 covered a matter, the Commonwealth could legislate, even if this intruded on areas traditionally managed by the states. The floodgates opened slowly at first, then with increasing force. The Corporation's Power, Section 51, Paragraph 20, the power to make laws with respect to foreign corporations and trading or financial corporations formed within the limits of the Commonwealth, was stretched to cover vast areas of economic regulation. The Work Choices legislation of 2005, which federalized industrial relations, rested on the corporation's power. If you worked for a corporation, the Commonwealth could regulate your employment. The state's industrial systems became largely redundant. The External Affairs Power, Section 51, Paragraph 29, the power to make laws with respect to external affairs, became a vehicle for importing international treaties into domestic law. Australia signs a treaty on human rights, or the environment, or labour standards. The Commonwealth then legislates to implement the treaty. The subject matter might be anything. The External Affairs Power on current interpretation gives the Commonwealth authority over matters that have nothing to do with relations between Australia and other countries, simply because a treaty exists. Tide Grants Power Section 96, which allows the Commonwealth to grant money to states on such terms and conditions as the Parliament thinks fit, became a mechanism for Commonwealth control over state activities. Want hospital funding. Accept Commonwealth conditions on how you run your hospitals. Want education funding. Accept the national curriculum. The Commonwealth cannot directly legislate on health or education, but it can use its financial dominance to achieve the same result. Vertical fiscal imbalance is the technical term. The Commonwealth collects most of the tax revenue. Income tax became exclusively Commonwealth during World War I, and stayed that way. The states depend on Commonwealth grants to fund their services. He who pays the piper calls the tune. States have become, in significant respects, administrative units, implementing Commonwealth policy, not independent governments pursuing their own vision. This was not what the founders intended. They created a limited Commonwealth, a federal system in which the states were the primary governments for most purposes. What we have now is something much closer to a unitary state, with regional administration. Was this evolution inevitable? Was it good? These are contested questions. But one thing is clear. It happened not through constitutional amendment. The people have rejected most attempts to expand Commonwealth power through referendum, but through judicial interpretation and financial pressure. The Constitution says what it always said. But what it means in practice has changed profoundly. The separation of judicial power. There is one area where the Australian Constitution is more explicit than most, and where its protections remain relatively robust. That is the separation of judicial power. Chapter 3 of the Constitution deals with the judicature. It creates the High Court. It allows Parliament to create other federal courts, and it vests the judicial power of the Commonwealth in those courts. The key word is vests. Section 71. The judicial power of the Commonwealth shall be vested in a federal Supreme Court, to be called the High Court of Australia, and in such other federal courts as the Parliament creates, and in such other courts as it invests with federal jurisdiction. Judicial power goes to courts, not to ministers, not to tribunals, not to administrative bodies. Courts. What is judicial power? The High Court has spent a century defining it, and the definition remains contested, but the core is clear enough. Judicial power is the power to determine disputes about existing rights and obligations according to law. When someone claims you owe them money, or that you committed a crime, or that the government has acted unlawfully. Resolving that claim is the exercise of judicial power. The separation works both ways. Courts cannot exercise non-judicial power. They cannot make policy, administer programs, or perform executive functions. And non-judicial bodies cannot exercise judicial power. They cannot finally determine rights and obligations in the way that courts do. This is a significant protection. It means that certain things cannot be done to you except by a court, a real court, with all the procedural protections that courts provide. The government cannot simply declare you guilty. It must prosecute you before an independent tribunal, following established procedures with a right of appeal. Administrative convenience is not a sufficient reason to bypass the courts. The Boilermakers case of 1956 established that federal judicial and non-judicial power must be strictly separated. The Commonwealth Court of Conciliation and Arbitration had been exercising both, settling industrial disputes, non-judicial, and enforcing awards, judicial. A high court said this was impermissible. Judicial power could be exercised only by courts, and courts could exercise only judicial power. The arbitration system had to be restructured. This principle has continued to limit what Parliament can do. Various schemes to take matters away from courts and give them to tribunals have been struck down. The protection is real, but it is under pressure. The rise of the tribunals. Alongside the courts, a parallel system has grown up: administrative tribunals that exercise powers which look very much like judicial power, but are carefully designed to avoid Chapter 3. I am not claiming that tribunals literally exercise Chapter 3 judicial power. The High Court has drawn those doctrinal lines. The question here is practical rather than formal, whether processes that stop short of adjudication can nonetheless impose penalties in everything but name. The Administrative Appeals Tribunal reviews government decisions. The Fair Work Commission handles industrial disputes. Human rights commissions investigate complaints of discrimination. Planning tribunals decide development applications. Migration tribunals review visa decisions, and on and on. These bodies have powers. They can compel attendance, require the production of documents, make binding determinations. They affect rights. They impose obligation. They can cost you your job, your reputation, your peace of mind. But they are not courts. They do not exercise judicial power according to their enabling statutes. They exercise administrative power, or review functions, or conciliation processes. The labels are chosen carefully by lawyers who understand Chapter 3 and know how to draft around it. The practical difference is significant. Courts have developed over centuries procedural protections designed to ensure fair outcomes. Rules of evidence: you cannot just assert things, you must prove them. Burden of proof: the person making the accusation must establish it to the relevant standard. Right to confront witnesses: you can challenge those who accuse you, test their evidence, expose inconsistencies. Right to legal representation: you can have a lawyer to help you navigate complex proceedings. Costs: if you win, the other side generally pays your legal expenses. This deters frivolous claims. Tribunals often dispense with these protections. They are meant to be informal, accessible, quick. The rules of evidence do not apply strictly. Legal representation may be discouraged or prohibited. Costs are usually not awarded, so there is no deterrent to unmeritorious complaints. The procedures are whatever the tribunal decides they should be. This can work well for minor matters, small claims, simple disputes, cases where the parties are unsophisticated and the stakes are low. It works less well when the stakes are high, when reputations are destroyed, when livelihoods are lost, and it works very badly indeed when the tribunal is captured by an ideology, when the procedures are designed to reach predetermined conclusions, when the informal process is a mechanism for bypassing the protections that centuries of common law development established. Moral managerialism. Here we come to something that should trouble every Australian who values liberty. The common law was built on a certain model of the relationship between subject, citizen, if you will, and state. The subject was free. The state could interfere with that freedom only for defined reasons, following defined procedures. The burden was on the state to justify its intrusion. Ambiguity was resolved in favor of liberty. Rights were negative. You had the right to be free from interference, free from assault, free from theft, free from arbitrary imprisonment. The state's job was to protect you from wrongdoers, not to make you a better person. Your thoughts were your own. Your speech was your own, subject to defined limits like defamation and incitement. Your choices were your own, provided they did not harm others. This model is being replaced by something different. Call it moral managerialism, or the therapeutic state, or the regime of sensitivity. The labels vary, the substance is consistent. Under the new model, the state takes responsibility not just for protecting you from harm, but for ensuring that you do not cause harm, with harm defined ever more expansively. Trace the progression. Early discrimination statutes prohibited discriminatory acts, refusing to hire, refusing to serve, refusing to rent. Later statutes extended to speech. What you said could now be unlawful. Later still, the concept of hostile environment emerged. It was not enough to refrain from discriminatory acts or speech. You must ensure the environment you create does not disadvantage. Now we have psychosocial hazards. The subjective feelings of those around you create legal obligations for you. Each expansion seems modest. Each can be justified in isolation. Stand back and observe the trajectory. The boundary of actionable harm has moved from acts to speech, to environments to feelings. At each stage the burden shifts further from accuser to accused. Consider how the standard of judgment has shifted. The common law asks, how would a reasonable person perceive this conduct? That is an objective standard, external, verifiable, independent of any individual's sensitivity. A jury of ordinary subjects could apply it because they were the reasonable people. Now consider the language of newer regimes. Psychosocial hazard includes feeling disrespected, feeling excluded, feeling unsafe, whose perception determines whether the hazard exists, not a hypothetical reasonable person's, the complainant's. The standard has moved from external to internal, from objective to subjective, and there is a further drift, more subtle still. Some statutes now speak of the reasonable person of that background or in the position of the complainant. This sounds like objectivity. There is still a reasonable person, but the reasonable person has been fragmented. There is no longer one standard applicable to all. There are multiple standards calibrated to group membership. What a reasonable person would perceive depends on which group the complainant belongs to. But even this does not capture what is happening in practice. Many statutes retain the language of the reasonable person without qualification, yet the decisions emerging from tribunals do not reflect what ordinary Australians would consider reasonable. How can this be? The answer lies in who interprets the standard. A reasonable person test is only as objective as the decision-maker applying it. If the decision-maker has been educated in institutions that teach a particular view of harm, trained in cultural competency, frameworks that treat certain sensitivities as self-evidently valid, and selected through processes that filter for ideological alignment, then their intuition about what a reasonable person would think will diverge from the broader community's understanding. The statute hasn't changed. The words reasonable person remain. But the person deciding what is reasonable has been formed by captured institutions. Their reasonable person is the reasonable, diversity-trained professional, not the reasonable person on the street. And so the standard drifts, invisibly, without amendment, without referendum, until the law, as applied, bears little resemblance to what the law as written would suggest. This is why the long march through the institutions matters. You do not need to change the law if you can change who interprets it. Under the old model, you were presumed innocent. The accuser bore the burden of proving wrongdoing to the satisfaction of an objective standard. Under the emerging model, the accusation itself carries weight. The complainant's perception is evidence. Your denial is defensiveness. Further evidence of the unconscious bias that caused the harm in the first place. The question shifts from "did this happen?" to "why won't you acknowledge what happened?" How do you defend yourself against a subjective standard? How do you prove you did not create a feeling? How do you demonstrate that a reasonable person would not have been offended when the decision-maker's conception of a reasonable person is not yours? These are not rhetorical questions. They are the questions every respondent to such a complaint must face, and the structure of the process provides the answer. You probably cannot win, but you will certainly pay. Chapter 3 and the Tribunals. Remember what Chapter 3 does. It vests judicial power in courts. It prevents judicial power from being exercised by non-judicial bodies. Now consider the structure of many modern administrative schemes. A complaint is made. A commission or tribunal investigates. It compels documents, summons witnesses, makes findings. It determines whether the respondent has contravened the law. It facilitates settlements, often under considerable pressure. It can refer matters to a court if conciliation fails, but most matters never reach a court. They are resolved, if that is the word, within the administrative process itself. Does this sound like the exercise of judicial power? The lawyers who design these schemes understand Chapter 3. They craft the legislation carefully to avoid the constitutional limits. The administrative body does not, technically, make binding determinations. It conciliates, it recommends, it refers. The final determination, if one is needed, is made by a judge. But ask yourself, by the time a court gets involved, if a court ever gets involved, what has already happened? The investigation has been conducted by the administrative body. The respondent has been required to answer. Documents have been produced. The pressure to settle has been applied. The reputational damage has occurred. Legal costs have been incurred. The stress has taken its toll. Years may have passed, and then, if the respondent has refused to settle and the matter proceeds to court, they face a judge. They may win, they may be vindicated, but they cannot recover the years, the costs, the reputation, the health. The process was the punishment. The court appearance is an afterthought. Is this what Chapter 3 was designed to permit? There is a strong argument that this arrangement violates the spirit of Chapter 3, even if it technically complies with the letter. The founders separated judicial power for a reason. They wanted the determination of rights and obligations to occur in courts with all the protections courts provide, allowing administrative bodies to conduct quasi-judicial processes, to impose quasi-judicial pressures, to inflict quasi-judicial consequences, and then requiring a final court sign-off that most matters never reach. defeats the purpose. The protections of the court are available in theory. In practice, they are bypassed by process. A governor-general who understood the constitutional structure might ask questions about legislation that creates these schemes, not to override Parliament's judgment, but to ensure that ministers have considered the constitutional implications, that the erosion of Chapter 3's protections is deliberate rather than careless. But we have a Governor-General who has said she can't read the bill and ask questions about it. What is that, if not a rubber stamp? The check does not operate. The brake is off. The Privy Council. There was once another check, an external one. Appeals could be taken from Australian courts to the Judicial Committee of the Privy Council in London. The Privy Council was the final court of appeal for the British Empire, and, later, the Commonwealth. It provided a uniform interpretation of common law principles across different jurisdictions. An Australian court, a Canadian court, an Indian court might take different views of a common law doctrine. The Privy Council could resolve the divergence, ensuring that the common law remained common. It also provided a check on local judicial tendencies. Judges are human. They are influenced by the intellectual fashions of their time and place. A court that knows its decisions may be reviewed by judges in another country, operating in a different intellectual environment, may be more careful than a court that knows it is the final word. The Privy Council's role in Australian constitutional law was always limited. Section 74 of the Constitution restricted appeals on inter se questions, questions about the relative powers of Commonwealth and states. But for other matters, appeals lay to London. This changed over time. In 1968, appeals from federal courts were abolished. In 1975, appeals from state courts in federal matters were abolished. Finally, in 1986, the Australia Acts abolished all remaining appeals. The High Court became, for all purposes, the final court of appeal. This was sold as independence, as Australia coming of age, as cutting the apron strings to the mother country, and there was something to that. A mature nation should have its own final court. Australians should not have to travel to London to get justice. But something was also lost. The High Court is now the final word on the Australian Constitution and on Australian law generally. 9 unelected judges, or 7 or 5, depending on the case, have the power to determine what the Constitution means, what the common law requires, what statutes permit. There is no appeal, there is no external review, there is no check. If the High Court gets something wrong, if it interprets the Constitution in a way that expands power beyond what the founders intended, or reads down protections that the common law provided, or defers to government when it should be skeptical, there is no remedy. The decision stands until the High Court itself changes its mind, or until the Constitution is amended by referendum. The Privy Council was a check. It provided an external perspective. It was staffed by judges who had no stake in Australian political disputes, no relationships with Australian governments, no career incentives to please Australian power centres. They could afford to be independent in ways that Australian judges, however honest, may find difficult. We gave that up. Whether we gained more than we lost is debatable, but we should at least acknowledge what we lost. To citizenship fiction. Let me turn to something that will surprise many Australians. You are not a citizen, or rather you are a citizen only because Parliament says so. The Constitution does not make you one. Search the Constitution for the word citizen. You will not find it except in Section 44. which disqualifies from Parliament anyone who is a subject or a citizen of a foreign power. The Constitution speaks of subjects of the Queen, now the King. It speaks of the people of the Commonwealth. It does not speak of citizens. A political community can be constitutionally presupposed without its membership being constitutionally secured. The Constitution assumes a people for electoral and representative purposes, but it does not entrench citizenship as a legal status beyond Parliament's control. Australian citizenship was created by statute, the Australian Citizenship Act, 1948. For that, Australians were British subjects, as were Canadians, New Zealanders, South Africans, and all other subjects of the Crown throughout the Empire and Commonwealth. This was not an oversight. The founders understood that they were creating a nation within an empire under a shared crown. Subjecthood was the common bond. An Australian could travel to London, work there, vote there, stand for Parliament there, because an Australian was a British subject, and Britain was where British subjects belonged. The same was true in reverse. A post-war decision to create separate citizenship categories was a practical response to changing circumstances. The Empire was becoming the Commonwealth. India was independent, soon to be a republic. The old unity of subjecthood was fraying. Separate citizenships provided a way to define membership in the new nations while retaining a residual connection through the Crown. But the constitutional position remains. The Constitution does not create or define citizenship. Parliament can change the rules at any time. Parliament can decide who is a citizen, how citizenship is acquired, how it can be lost. There is no constitutional right to citizenship, no constitutional protection against denaturalization. This has consequences. When Parliament decides to strip citizenship from dual nationals involved in terrorism, it can do so subject to whatever limits the High Court derives from the Constitution's structure or from Chapter 3. When Parliament decides to impose conditions on citizenship, to require tests, to create waiting periods, it can do so. Citizenship is what Parliament says it is. Contrast this with the American Constitution, which provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. American citizenship is constitutional. Congress cannot simply decide that some Americans are no longer citizens. The Constitution protects the status. Australian citizenship has no such protection. We are citizens at Parliament's pleasure. This is not necessarily a problem. Parliament has, on the whole, been responsible in its management of citizenship. The rules are reasonably clear, the criteria reasonably fair. But the point is that this is a matter of parliamentary grace, not constitutional right. What Parliament has given, Parliament can take away. The 1967 myth. While many Australians associate the 1967 referendum with the conferral of basic rights on Aboriginal people, that understanding does not reflect its legal or constitutional effect. The referendum did not grant Aboriginal Australians citizenship. It did not give them the right to vote. Those matters were already governed by statute, not by the Constitution, and had been addressed separately over time. Australian citizenship had been created by the Nationality and Citizenship Act 1948. The right to vote in federal elections had been extended to Aboriginal Australians in 1962, with enrolment becoming compulsory later. Before that date, voting rights varied between states, as did voting rights for many other Australians, including women, the propertyless, and itinerant workers. None of this was altered by the 1967 referendum. What the referendum did was amend the distribution of constitutional power. two provisions were changed. First, Section 127 was repealed. That section had provided that Aboriginal natives were not to be counted in reckoning the population of the Commonwealth or of a state for constitutional purposes. This was not a statement about legal status, citizenship, or humanity. It was an administrative and federal provision concerned with representation and funding. Parliamentary representation in the House of Representatives was tied to population figures, and population figures were assumed to reflect people administered through ordinary political and fiscal systems. At the time of Federation, Aboriginal populations were largely governed under separate state regimes and, in many cases, lived outside the census mechanisms available to 19th century governments. They were not uniformly enrolled, taxed, or administered through the institutions on which Commonwealth representation was based. Including them in population counts for Commonwealth purposes would therefore have produced unreliable and potentially distortive results. Section 127 addressed that practical difficulty by excluding populations for whom the Commonwealth bore no direct political responsibility. Second, the referendum amended Section 51, paragraph 26, the so-called race power. Before 1967, the Commonwealth was empowered to make laws with respect to people of any race other than the Aboriginal race in any state. That reservation of power to the states was deliberate. Aboriginal affairs were regarded as matters for state governments, which were thought better placed to manage local conditions and welfare arrangements. The arrangement was paternalistic, reflecting the assumptions of the era, but it did not deny Aboriginal people legal personality, protection of the law, or membership of the political community. They were subjects of the Crown, like other Australians. The 1967 amendment removed that reservation. From that point onward, the Commonwealth acquired legislative power with respect to Aboriginal people concurrent with the states. The referendum therefore expanded Commonwealth competence. It did not create rights, it altered jurisdiction. Whether that expansion of power was beneficial is a separate question. Supporters of the referendum believed that national responsibility would produce more consistent and humane policy outcomes than the existing patchwork of state administration. Critics worried about centralization and the displacement of local control. Reasonable people differed then, as they do now, but as a matter of constitutional fact, the referendum did not recognize Aboriginal people as citizens, did not enfranchise them, and did not confer substantive rights. The significance of 1967 lies not in symbolism, but in structure. It marked a transfer of authority from the states to the Commonwealth. Later, political narratives transformed that institutional change into a moral story of recognition and inclusion. That story may have rhetorical force, but it should not be confused with what the Constitution actually did. Understanding this distinction matters, because it reminds us that the Australian Constitution is not a charter of values or a Bill of Rights. It is a framework for allocating power. The framers assumed that questions of welfare, justice, and social improvement would be addressed through ordinary politics and legislation, not by symbolic alteration of constitutional text. 1967 referendum fits squarely within that original understanding. Judicial activism. One more topic must be addressed before we close: the role of the High Court itself. The High Court is the guardian of the Constitution. It interprets the document, resolves disputes about its meaning, strikes down laws that exceed constitutional limits. This is an awesome power. It is also a power that can be abused. The temptation for judges is to read their own views into the Constitution, to find in the document what they think should be there, rather than what the founders put there. This is called judicial activism. It turns judges into legislators, making law rather than interpreting it. The Mason Court of the early 1990s succumbed to this temptation. A series of decisions The High Court discovered implied freedoms in the Constitution, freedoms that are nowhere stated in the text, but are, the Court said, implicit in the constitutional structure. The implied freedom of political communication was established in Australian Capital Television versus Commonwealth, 1992, and Maichio News versus Wills, 1992. The Court held that the Constitution's provisions for representative government implied a freedom to discuss political matters, and that laws restricting political communication were unconstitutional unless justified by a compelling purpose. This sounds reasonable. Political communication is important. Representative government does require an informed electorate, but there is a problem. The founders knew how to protect rights explicitly. They included a handful of express rights in the Constitution: the right to trial by jury for indictable Commonwealth offences. Section 80, the right to just terms compensation when property is acquired. Section 51, paragraph 31, freedom of religion. Section 116, freedom of interstate trade. Section 92. They could have included freedom of speech. They chose not to. The implied freedom is not a right possessed by individuals. It is a limitation on legislative power, a structural feature of the Constitution, rather than a personal entitlement. But it functions like a right, and it was created by judges rather than by the framers. Once the Court started finding implications, where would it stop? If political communication is implied, why not other communications? If representative government implies free speech, why not free association, free assembly, free press? Constitution could be made to imply a whole Bill of Rights, exactly what the founders decided against. The Court has been relatively restrained since the Mason era. It has not discovered many new implied freedoms, but the precedent is there. The door is open. And a future court, with different composition and different inclinations, might walk through it. This is why judicial appointments matter. This is why the composition of the High Court is a political issue, even though we pretend it is not. The judges who sit on the court will determine what the Constitution means for a generation. If they are inclined to find implications, they will find them. If they are inclined to respect the text and the founders' intentions, they will do that. The choice between these approaches is not legally compelled. It is made by human beings with views, preferences, and philosophies. The separation of judicial power in Chapter 3 is meant to ensure that judges decide according to law, not according to preference. But when the law is the Constitution, and the Constitution is ambiguous, the judge's preference inevitably shapes the interpretation. There is no escape from this. The most we can do is appoint judges who understand the danger of judicial activism and are committed to restraint. And here, once again, the Governor-General could play a role. The appointment of High Court judges is formally made by the Governor-General in Council. That is, by the Governor-General acting on the advice of the Federal Executive Council. A Governor-General who took the constitutional function seriously might ask about proposed appointments, might consider whether nominees have the qualities appropriate for the role, might exercise the bag-hot rights to be consulted, to encourage, and to warn. But we have a Governor-General who believes her understanding of matters is completely irrelevant to her function. The check does not operate, the brake is off. What we have and what we are losing. Let me draw this lecture to a close. We inherited protections that no single document could capture. The common law, with its presumption of innocence, its burden of proof, its procedural safeguards, its centuries of accumulated wisdom about how to balance liberty and order. We inherited federalism, a division of powers designed to prevent concentration, to keep government close to the people, to allow diversity and experimentation. We inherited the separation of judicial power, the requirement that determinations of rights and obligations occur in courts, with all the protections courts provide. We inherited an external check in the Privy Council, which we gave up, perhaps necessarily, but not without cause. We inherited a constitutional structure that the founders believed would protect liberty better than any Bill of Rights, a structure of dispersed power, responsible government, and common law rights. All of this is under assault. The common law is being displaced by administrative schemes that bypass its protections. The tribunals multiply. The subjective standards spread. The burdens shift. The presumption of liberty gives way to the presumption of regulation. Federalism is hollowed out by financial dominance and expensive interpretation. The states become administrative units. The Commonwealth occupies fields the founders reserve for local government. The separation of judicial power is circumvented by clever drafting. Tribunals exercise quasi-judicial power without judicial protections. The process becomes the punishment. The external check is gone. The High Court is final, and the High Court can be activist. And the Governor-General, who should be the guardian of the constitutional structure, declares herself a rubber stamp. Inheritance is real. The inheritance is precious. And the inheritance, if we are careless or ignorant, can be lost. In the final lecture, we shall examine how the inheritance is being deliberately dismantled, not by constitutional amendment, which would require the people's consent, but by administrative erosion, symbolic destruction, and the slow replacement of what we have with something quite different. The Republic is coming, not through the front door, but through the back, and most Australians do not even know it is happening. End of Lecture 3.